It was MDA Freeman who once said that law is derived from social facts and depends not on state authority but on social compulsion. Law differs little from other forms of social compulsion, and the state is merely one among many associations, though it possesses certain characteristics, means of compulsion. The real source of law is not statutes or reported cases, but the activities of society itself. So I want us to bear this statement in mind as we discuss, the origin of law as conceived by proponents of the sociological school of thought. Now, the statement by M.D.A. Freeman in Lloyd's Introduction to Jurisprudence reflects the central claim of the sociological school that law originates in society, not merely in the state. So that unlike legal positivists such as John Austin, who viewed law as the command of the sovereign, sociological jurists argue that law emerges from social interaction, from customs, from institutions, and the practical needs of the community. In essence, sociological jurisprudence treats law as a living institution shaped by social realities and designed to regulate social relations so that the state may formalize law, but it does not create its substance. In other words, it is society that does. So, what is the meaning of the sociological school of thought? The sociological school studies law in its social context. It asks the following questions: how does how does society shape law? How does law affect society? And what social needs does law serve? Roscoe Pound described law as social engineering. That is a tool for balancing competing interests in society. According to Pound, law is not an abstract command, but an instrument for achieving social order. The core proposition by Pound is that law originates from social facts, from customs, from social pressure, and community expectations. So that people form a queue at a bus stop not because Parliament passed a law requiring them to queue, but because society expects order. So that social expectation can later evolve into enforceable law. Now, let's look at the origin of law according to major sociological jurists. And the first major sociological jurist is Eugene Ellich, who stated that law originates in social associations, that is, living law. And Eugene is considered the father of sociological jurisprudence. He argued that the true center of legal development is society itself and not legislatures or the courts. According to Eugene, the living law is the law which dominates life itself. His argument is that law comes from family relations, it comes from trade practices, it comes from social customs, and it also comes from community obligations before it becomes state law. And a good illustration is that marriage existed as a social institution long before formal marriage statutes, so that now social practice leads to social acceptance, which leads to legal recognition. If you look at the case of Carlyle versus Carbolic Smoke Ball Company, the facts of this particular case were that a company advertised rewards for anyone who used their product and still got sick. And the issue was whether the advertisement was legally binding. And the rule is that custom and commercial practice can create legal obligation. And the application of this case was that the court recognized business practice and societal commercial expectation. The conclusion of this case is that law followed social commercial conduct. So what is the relevance of this case? You see, this case shows, the rise of law from socioeconomic interaction, which is in line with the theory by Eugene. The second major sociological jurist is Roscoe Pound, and this guy viewed law as social engineering. Pound believed that law originates from the need to balance competing social interests, in that law exists to protect individual interests, to secure public interest, and to preserve social interest. Pound compared lawyers and judges to engineers designing social order. In fact, his famous idea is that law equates, social engineering, meaning that law is constructed from social needs. And a good example to illustrate this is traffic laws, which emerged because of increased, motor vehicle use, which created, social conflict and danger. So that a society with no cars, does not need traffic rules. Hence, social needs, can create law. If you look at the case of Donoghue versus Stevenson, the facts of this particular case were that Mrs. Donoghue drank ginger beer containing a decomposed snail, and the issue was whether the manufacturer owed her a duty of care. And the rule is that, manufacturers owe consumers a duty of care. And the application of this particular case was that the court responded to changing industrial society and consumer protection needs. So the conclusion of this particular case was that the manufacturer was liable. So the sociological significance of this case is that law evolved because society changed. The third major sociological jurist is Leon Duguid, who stated that law originates from social solidarity. Now, Leon rejected, the theory of sovereignty. He argued that law is based on social solidarity, that is, the interdependence of people in society, in that people depend on each other for survival. And this creates, what we call social duties, so that law now emerges to regulate these particular duties. And a good example is, employment law, which exists because employer and employee depend on each other. If you look at the case of Mogul Steamship Company Limited versus Go and Company, this case, reflects economic interdependence and regulation of competition. So Leon will argue that law developed to preserve economic social solidarity. The fourth major sociological jurist is Oliver Wendell, who stated that law comes from experience. So Holmes famously stated that the life of the law has not been logic, it has been experience, meaning law develops from practical human experience, not theory, not abstract morality, and not sovereign command. A good example is, digital privacy law arose because society experienced data abuse. If you look at the case of Brown versus Board of Education, the facts of this case, concerned racial segregation in schools. And the issue was segregation constitutional? And the rule is that there is equal protection under the law. And so the application of this particular case was that the court recognized social realities of inequalities. So the conclusion was that the segregation was actually found to be unconstitutional. So that the sociological relevance of this case was that law adapted, to social change. Let's now look at the Kenyan context of the sociological origin of law. You see, Kenya strongly reflects sociological jurisprudence. First, it reflects sociological jurisprudence through the Constitution of Kenya 2010. You see, the Constitution reflects social demands for human rights, for accountability, for devolution, and also for equality. So that these emerge from Kenya socio-political struggles. Hence, constitutional law came from social realities. Secondly, Kenya strongly reflects social jurisprudence through customary law recognition. Under the Judicature Act, African customary law is actually recognized. And this proves that law can originate from community practice and not necessarily parliament. If you look at the case of Kinyanjui Kimani versus Muiru Kiganga, the facts of this particular case was that there was a dispute involving Kikuyu customary law. And the issue was whether customary law can be enforced. And the rule is that customary law applies if it is not repugnant to justice and morality. And the application of this case was that the court recognized community norms so that custom was actually recognized as law. Now, the sociological significance of this particular case is that law existed in society before even state recognition. In the case of Otieno versus Ougo, which is famously known as the SM Otieno burial case, the facts of this particular case involve a dispute over burial according to Luo custom. And the issue was whether customary law governed burial. And the rule is that customary law applies in personal law matters. And the application was that the court upheld Luo customs so that burial, was governed by custom. The significance of this case is that social norms shaped legal outcomes. Now, let's look at the strength of the sociological theory. And the first strength of the sociological theory of law is that it reflects reality. You see, law mirrors real social life. And a good example is cybercrime laws arose because cybercrime actually emerged. The second strength of sociological theory is that it is flexible in that law changes with society. A good example is that environmental law developed from climate concerns. The third strength of sociological theory of law is that it recognizes custom, and this is very important in African legal systems since customary law remains central in African legal systems. The third strength of the sociological theory of law is that it promotes justice. You see, law responds to actual human needs, not rigid formalism. Now, let's look at the criticism of the sociological theory of law. The first criticism of the sociological theory of law is that it is too uncertain, in that social norms, tend to vary, and this may cause inconsistency in the application of law. The second criticism of the sociological theory of law is that it weakens legal certainty, in that people may not know what the law actually is. The third criticism of the sociological theory is that it gives judges excessive power, in that judges may impose personal social views. The fourth criticism of the sociological theory is that it can justify oppressive customs, in that not every social practice is actually unjust. And a good example is discriminatory customs in Kenya. Now, I want us to look at the comparison between, the sociological theory of law with other schools of law in the world. And the first one is natural law. And the source of natural law is morality and also reason. The second is positivism. The source is sovereign or the state. The third is historical, and the source is custom or history. And the fourth is sociological law, which the source is social facts or social needs. So that the sociological school differs, by grounding law in living social reality. The conclusion is that the sociological school views law as a social product, so that the state is not the creator, but the formalizer of law. So that jurists like Eugene Pound, Leon and Oliver agree that law emerges from social interactions, from social needs, and also from social pressure. Now, Freeman's extract captures this accurately, in that law is born in society before it is written in statutes or declared in courts. So that in modern Kenya, constitutional reforms, customary law, human rights law, and public interest litigation all demonstrate that that not necessarily law, but that society remains, the real source of law. My name is Biketi. If it is your first time here, make sure to follow this channel and to subscribe for more legal lessons.